All rise. The Honorable Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Good evening. Are you ready to proceed?
Yes, Your Honor.
Yes, ma'am.
All right, we start with petitioner. You may proceed.
Madam Chief Justice, and may it please the court. My name is Kayla Griesemer, and I, along with my co-counsel Blake Meadows, represent the petitioner, Mr. Chester Comerford. I will be addressing the issues that arise under the Fourth Amendment, and my co-counsel will address those that arise under Article 2. At this time, we ask to reserve 3 minutes for rebuttal.
You may.
Thank you, Your Honor. On the issue of the Fourth Amendment, we ask this court to rule that the warrantless tracking of a cell phone violates the Fourth Amendment's protections of persons and effects. We ask for this ruling for the following 2 reasons. First, that the monitoring of Mr. Comerford's cell phone through his IMSI is an electronic trespass. And second, that Mr. Comerford has a reasonable expectation of privacy.
What is an electronic trespass?
Your Honor, an electronic trespass is something that this court recognized the possibility of occurring in its decision in United States v. Jones. Although there has traditionally been a physical element in a trespass, the definition laid out in Jones as well as Florida v. Jardines can now be met through technological advancement without having this physical element. And that technological component should not remove...
So how would you define an electronic trespass?
Well, Your Honor, the definition in Jones requires that 2 specific prongs be met. First, that there be a constitutionally protected area, and second, that the government invade upon that area. The constitutionally protected area in the present case is Mr. Comerford's cell phone, protected directly as an effect under the Fourth Amendment. The invasion in this case occurred when the FBI forced Mr. Comerford's cell phone signal to reveal its encrypted IMSI number. And then, rather than acting as any other cell phone tower and releasing the signal, the chum forced the signal to remain connected indefinitely with the chum to transform Mr. Comerford's own private and personal property into a tracking device for the police to monitor.
How do you define private and personal property?
Your Honor, the cell phone was owned by Mr. Comerford, and the contract that he signed with the phone company allowed for specific uses of his cell phone signal. This goes to what this court defined in Florida v. Jardines as implicit versus explicit consent. In that case, this court delineated that there was implicit consent when an individual poured a sidewalk to their front door, that guests could come onto their property, knock on the door, and if they were not home, leave. It was in no way consent for the police to bring a bloodhound onto their property and conduct a search. In the same way, Mr. Comerford sending out a cell phone signal is implicit consent for him to receive phone calls and contracted services. In no way is Mr. Comerford giving his implicit consent for law enforcement to detain indefinitely his cell phone signal and turn his own...
Isn't a cell phone different, however, than your own personal property, or do you have a right to that personal property as opposed to using a cell phone nowadays? Everybody uses a cell phone.
That's exactly the point, Chief Justice Silver. Because cell phones are so ubiquitously used in today's society, to expect society to know that the government could use such an integral tool to professional and personal life to monitor a citizen's every movement is a frightening precedent under the Fourth Amendment.
But can't the government monitor people's movements without violating the Fourth Amendment or just following them around?
Certainly, Justice Bender.
How does this differ from that?
This differs substantially, which moves to Petitioner's second argument, that Petitioner has a reasonable expectation of privacy against dragnet-type law enforcement. This court defined dragnet in both United States v. Jones and United States v. Knotts as the government gathering either a spread of information about a large number of individuals or a large amount of information about a single...
Have you ever held that following somebody around is invasion of privacy?
No, Your Honor. However, this is not simply the police following Mr. Comerford around. The chum has capabilities far greater than visual surveillance could ever have. This court discussed in Knott's the idea that dragnet surveillance, which was used in the case of Mr. Comerford, was the potential for 24-hour surveillance at the push of a button for law enforcement to use an electronic device to monitor citizens' movements without any practical considerations of police limitation.
What's your best case? And explain to me, based upon the competing precedents of the Supreme Court of the United States, how that case best supports your position.
Your Honor, the case that petitioner would draw this court's attention to is Cardwell v. Lewis, as cited in United States v. Knott's. In that case, this court stated that beeper surveillance in both Knott's and United States v. Kara was constitutional because a vehicle has little capability to escape public scrutiny. And for that reason, beeper surveillance could be used to track this vehicle. However, an individual, and certainly that individual's cell phone, has a great capability to escape public scrutiny. And for this court to say that there is no expectation of privacy, that one's own property cannot be turned into a tracking device of the police, would be a sweeping override of all Fourth Amendment protections up till this time.
But again, they can follow them around themselves. What's the difference? What's the big deal?
Your Honor, this is a large consideration under the Fourth Amendment. The difference between this and visual surveillance is that the chum can gather information that visual surveillance cannot.
Such as what in this case?
In this case specifically, Your Honor, the record clearly states that the chum was able to tell law enforcement when Mr. Comerford entered and exited his home, and was able to verify his continued presence inside of his home.
But they could have done that with 6 officers and pay them a bunch of money. Does the Fourth Amendment just mean that we have to spend a lot of money to surveil someone?
Not at all, Chief Justice Brain, but what the Fourth Amendment does require is what this court laid out in Silverman v. United States, as cited in Knott's, where they drew an analogy between year-round surveillance outside of a home, watching who enters and exits, as being perfectly constitutional. However, an officer actually physically breaking into that home to ensure that someone was still inside was a Fourth Amendment violation. And in the case at bar...
Do you agree that having officers outside somebody's home on a 24-hour basis, watching when they go in, when they go out, and following them over a period of a couple of months is not an invasion of privacy?
Your Honor, petitioner would contend that this could constitute a type of dragnet law enforcement, and certainly using an electronic device to do this that can be operated at the push of a button is a dragnet type law enforcement. But another concern that is raised concerning Justice Brain's previous question is that the chum is able to virtually intrude on Mr. Comerford's home and verify his continued location inside of his home.
Well, actually, just verify that the phone's still there. He can leave it if he wants, right?
Correct, Your Honor. However, even this is a more intrusive violation of Mr. Comerford's Fourth Amendment rights. As this court ruled in Kayla v. United States, if law enforcement knows that a closet light is on inside of the house, they must have a warrant. Certainly to know that Mr. Comerford's cell phone or Mr. Comerford's own person is still inside the home is something that law enforcement cannot know through simple visual surveillance, and they must have a warrant to obtain this type of information. To say that there is not an expectation of privacy over an individual's cell phone signal, a tool that is so prevalently used in today's society, would be to remove any expectation that an individual cannot be.
Can I ask you about that? Being so prevalent, aren't most people aware that cell phones have a GPS function and that you can be tracked where you're going? Why is there a reasonable expectation that if a third party can track your movements, why would it be unreasonable to think that the government could also do that?
Your Honor, respectfully, individuals don't expect for a third party to track their movements. A cell phone tower might know an individual's location within a 20 to 30 mile radius in order to know which cell phone tower they're connecting to, but they in no way monitor an individual's every movement, such as the chum does. This would constitute something...
Why couldn't they? I mean, if it's available, in other words, there's nothing precluding them from doing so. So the question is reasonable expectation of privacy, meaning, is it something that the public, not only, there are two components of it, which is a subjective basis, and I don't know that I've seen in the facts or understand in the facts that there's evidence of a subjective basis, but even if you have that under CATS, you have to have an objective basis where society believes that this is unreasonable. And here, just as my colleague Justice has stated, GPS is well known. Everybody knows, it seems to me, you can take judicial notice perhaps, everybody knows that GPS, if they wish to do so, they can find you.
Your Honor, I see my time has expired. May I answer your question?
Yes, you may.
Certainly, Your Honor. First, regarding Mr. Comerford's subjective expectation of privacy under CATS versus the United States, he has taken measures to ensure his privacy. And then looking specifically to whether society would recognize these as reasonable, although cell phone companies and GPS technology is able to locate an individual, they do not use that information on a regular basis for anything other than roaming charges and knowing a general area in which a person is, unless that individual allows on their device for that information to be used. There was in no way consent given by Mr. Comerford or by society at large that the law enforcement should have unlimited authority to track their every movement by means of transforming their personal property into a government GPS tracking device. And it is for this reason that we would ask this court to overturn the decision of the 14th Circuit. Thank you.
Thank you. You may proceed.
Thank you. Madam Chief Justice, and may it please the court, my name is Blake Meadows, and I rise to continue arguments on behalf of the petitioner, Mr. Chester Comerford. We ask this court to recognize that Mr. Comerford's indefinite detention was not authorized by either the Constitution or Act of Congress. We ask for this holding for the following three reasons. First, indefinite detention cannot be applied to unlawful enemy combatants. Second, civilian...
You would be happy if they said they're going to keep him for 50 years?
Absolutely not, Your Honor.
So the indefinite is not relevant. I don't understand why you talk about indefinite detention as if that made a difference. Suppose the president said we're going to keep you here for 25 years. Would that be okay with you?
No, Your Honor, it would not be okay, but the facts of the case at bar is that he's being detained indefinitely with no foreseeable end to that detention and no promise that he will ever be given a trial. That is indeed the bright line this court has elucidated between lawful and unlawful enemy combatants. The two classifications of individuals this court has recognized in regard to combatants are lawful and unlawful. Lawful combatants or lawful belligerents are prisoners of war, and they are the only classification of individuals which can be detained indefinitely. The only reason they can be detained indefinitely is because they are detained until the cessation of hostilities with which they are associated, and there's no means of knowing when they are captured, when that cessation of hostilities will be reached. In the case of unlawful enemy combatants, these are individuals who are charged with a violation of some law or the laws of war. That is how Mr. Comerford has been classified, and as such he is entitled to the rights and privileges of an unlawful enemy combatant.
Well, but what sense does that make? You're treating lawful combatants better than unlawful ones. Shouldn't it be flipped?
Your Honor, unlawful combatants are being dealt with in an entirely different set of circumstances because there are actually charges being brought against them for violation of some law. And as such, it must be shown that those charges are indeed proven before a court of law before they can be punished. And that's what's lacking in the case at bar. Mr. Comerford is being treated as a criminal, presumed guilty, not innocent. He's being punished before he's ever been taken before a court of law to determine whether or not he's actually guilty of the allegations that have been made against him. At this point in time, Mr. Comerford is facing a situation where he could be potentially detained for the rest of his life without ever having his day in court, without ever having the ability to prove his innocence before a court of law on mere suspicions. That is indeed the problem with the case at bar. The president...
What are the allegations that are made against him?
It is alleged that he has attempted to purchase a dirty bomb or a nuclear device of some sort.
Has that ever been formally alleged against him?
Yes, Your Honor, that is the reason supposedly for his detention, but it has never been actually taken to a court of law. And when that evidence...
Has there been any kind of a hearing about that?
Yes, Your Honor, that evidence and all the evidence gathered by the FBI was presented to a grand jury, and they failed to indict Mr. Comerford. They considered that evidence less likely than not that he had any connection to a dirty bomb whatsoever, and the president still stepped in and is detained him for an indefinite period of time. At this point, nearly 2 years.
And he's in military detention now, right?
Yes, Your Honor.
Has there been any kind of military hearing as to whether he is an unlawful combatant or an enemy or anything like that?
There's been a hearing, but it is a hearing only applicable in the case of lawful combatants. If we look at the case of Hamdi versus Rumsfeld, this court outlined, and later in the case of Boumediene versus Bush, this court explained a process whereby lawful combatants could have a review status tribunal evaluate whether or not they were indeed a combatant. That was applied to Mr. Comfort, but that is not the proper standard which should have been applied given the charges that were supposedly made against him. That standard is only applicable to an individual who is indeed a lawful combatant, captured on a foreign theater of war, engaged in actual combatancy on a lawful nature.
And why is that?
Because
which case are you relying on for that?
Hamdi versus Rumsfeld, Your Honor, which expressly explained the difference between lawful and unlawful combatants. In the case of a lawful combatant, there's no punitive nature to their detention, and there's no sense of shame attached to their detention. It's a mere necessary incident to war. In the case of unlawful combatancy, there's a degree of punishment and shame attached to that detention, and it must be proven in a court of law when it is at all feasible that a court take place, that they actually have the ability to prove that this individual is guilty. The only exception to the ability to try an individual before detaining them is one of geographic concern. If the individual is captured in a foreign theater of war, such as in the cases of Hamdi versus Rumsfeld and Boumediene versus Bush, the government in that case can wait till they can transport that individual to an area where a trial would be feasible. There are no such geographic concerns in the case at Barr. Mr. Comfort was captured on American soil by American federal investigators, and there's no reason that he could not go to trial today. The only reason he has not gone to trial is because the president has chosen not to give this American citizen his rights in the
When he was initially captured, what offense was it for?
Your Honor, presumably the federal investigators captured him both for his attempt to purchase a nuclear weapon, or the alleged attempt rather, and for his possession of drugs. He was in the process of serving out or dealing with a plea bargain on the drug charges at the time the president apprehended him and moved him into military custody.
When he was captured, it was just for the drug charge?
No, Your Honor, it was both. Both sets of evidence were presented. Pardon?
How do we know that?
Your Honor, what the record indicates is that all the evidence, both gathered at the warehouse and at Mr. Comfort's home, were presented to a grand jury. The grand jury did not consider there to be sufficient evidence to indict Mr. Comfort for any attempt to purchase a nuclear weapon of any kind. They did see sufficient evidence to indict him for drug charges, and he was working through a plea bargain at the time the president transferred him to military custody.
Why don't the facts actually establish that the authority of the president that it exists, that there are threats that have materialized?
Your Chief Justice Silver, nothing in the record indicates anything other than what I've presented to you. The only evidence presented in the record is that federal investigators have found a document supposedly incriminating Mr. Comfort. When they presented this evidence to a grand jury, the grand jury failed to indict him. They considered that evidence less likely than not that he was at all tied to the alleged facts.
Are those facts any different than the Price cases?
Your Honor, there are some material differences between the Price cases and the case
what are they?
In the case of the Price cases, we were dealing with a state of war between different states within the Union, namely the Civil War, and we had war materials actually captured on ships being transported past a blockade. So there was a... So
this was not a war, even though they called it the War on Terror, even though as a consequence of what happened at 9/11, the president declared a war on terror.
Your Honor, it is not petitioner's contention that there's not an ongoing war, but rather that Mr. Comfort has no part in that war. There's no connection between...
But those are facts. Those are facts based upon why doesn't the President of the United States have discretion based upon the facts in this record, as the President of the United States did in the Price cases?
Your Honor, what we see in the case of Ex parte Milligan and in the Price case is that the President, while he has a broad grant of power to deal with a wartime situation, does not have a blank check. In the case of Ex parte Milligan, Mr. Milligan, because he was captured in the state of Indiana, where the courts had not been suspended by Congress, was not able to be transferred to military jurisdiction, even though the Civil War was fully functioning, and it would appear that Mr. Milligan was aiding and abetting the Confederate States of America. At this point in time, Mr. Comfort has a much less degree of certainty of any involvement with any illegal actor, and for the President to think that he can use a broad idea of war powers to step in and...
The President thinks that he is an enemy of the United States, fighting against the United States in the war on terror. What do you think the President should do?
Your Honor, I see my time is expiring. Chief Justice Silver, may I still answer?
Yes.
We see that when an individual is engaged in acts of war against the United States, it is critical to understand whether or not their actions are actual legal acts of war or alleged actions of unlawful activity. In the case of Mr. Comerford, the president chose to classify Mr. Comerford as an unlawful enemy combatant, and yet in choosing to do so, failed to give him his rights before this court and before the law, which specified that he must be given a trial.
What do you think the president should have done?
Your Honor, Chief Justice Justice Silverman still answering the question. What the president should have done in this case is exactly what he did plus one step. He should have detained Mr. Comerford and given him a trial. The problem is the president has not given him a trial. He's not given him the ability to prove his innocence.
Trial for what? What charge?
For his conspiracy to purchase a nuclear weapon. If Mr. Comerford is guilty of trying to purchase this, they should be able to prove that in the court of law. If they cannot prove it, Mr. Comerford should indeed be released.
Why is there less likely that he's a belligerent than in the Price case?
Your Honor, my time is still expired. May I still answer the question?
I'm sorry to ask you that again at the very end, but would you answer it, please?
Your Honor, the distinction is that Mr. Comerford is not being held as a lawful belligerent. In the case of the Price cases, individuals were captured carrying war materials through a blockade. There was no doubt that those materials were being carried across by these individuals, and they were captured with the materials in their possession. There was not some document alleging the facts against them. Furthermore, they were not...
The document?
Pardon?
The document? The document in this case, you're saying?
That is all that is existing in the case at bar.
Are you talking about the complaint, or are you talking about an affidavit? What document?
Your Honor, the record makes it clear that federal investigators found a document which seemingly incriminated Mr. Comerford. That is the only evidence that has been presented in the record.
And it was unreliable as far as you're concerned.
Your Honor, it's impossible to determine at this point in time the degree of reliability. A grand jury did not consider it reliable, but it's never been presented before a court of law. All that Mr. Comerford is asking is that this be presented before a court of law to determine his guilt or innocence.
Thank you.
Thank you very much, Your Honor.
And you may proceed.
Madam Chief Justice, Your Honors, and may it please the Court. My name is Ashely Hall. My co-counsel is Kyle Maury, and we represent the respondent in the immediate case, the United States of America. In our time before the Court today, I will address why the FBI's tracking of the signal emitted by Chester Comerford's cell phone did not violate his reasonable expectation of privacy and thus did not infringe upon his Fourth Amendment rights. And later, my co-counsel will address why the President was acting within his authority when ordering the indefinite detention of Chester Comerford. Your Honors, the Fourth Amendment issue in this case is about balancing the guaranteed right to privacy with the government's interest in ensuring public safety without being technologically handicapped. The FBI's actions were...
Why would it be a handicap to get a warrant?
They are, Your Honor, if they're not allowed to use routine technology, which was used in this immediate case. Because as this Court has noted, in the case of Kayla versus United States, law enforcement need not obtain a warrant when using routine technology to conduct surveillance.
Yeah, but in this particular case, since they're doing a comprehensive following of this person, why is it a simple thing to do to go get a warrant? And then you don't have a constitutional problem.
Your Honor, because law enforcement does not need to obtain a warrant unless a search occurs. And as this Court has noted, in the case of United States versus Jacobson, as cited within the case of United States versus Kayla, a search occurs when a reasonable expectation of privacy is violated. Therefore, we must look to the Katz analysis to establish if Chester Comerford has a reasonable expectation of privacy that has been intruded upon.
But the chum didn't actually just monitor his cell phone, it actually made it do something, didn't it?
No, Your Honor. It simply was able to track naturally emitting signals. Because as noted on page 4 of the record, every cell phone constantly searches for and sends signals to cell phone towers. Additionally, noted on page 4 of the record, every cellular network relies upon IMSI technology to detect the location of the phones of their subscribers, so they know who to give service to. Therefore, an inherent part of this cell phone is that it conveys information regarding its location to the IMSI catcher. Therefore, law enforcement did not force this device to convey its information.
Would it matter that if the general public didn't know that information was kept? Trying to get at whether there's a reasonable expectation of privacy. Is it common knowledge that not only does it get the signal and send it back, it can send it to someone else, as opposed to just being there and getting the signal from the phone? Would it matter if no one understood that technology was out there?
No, Your Honor, and I can answer your question on 2 points. First, that this court has noted that although society may not understand all the esoteric functions of a particular technology, they may understand its common use. Therefore, if society does not understand all the intricacies of IMSI technology, they do understand the common use of a cell phone, and that is to have communication capabilities.
Well, we're talking about a reasonable expectation of privacy. Should I be reasonably expecting every time I leave the house that the police are following me?
Your Honor, if you are conveying your movements in the public, then that is public information. You may not need to reasonably expect
every
that.
person in the society should expect to be followed by the police whenever they go outside.
Not to be expected to be followed by the police, Your Honor, but rather to know that information is public information.
Oh, I know, but what does that have to do with the feeling of privacy?
Your Honor, the reasonable expectation of privacy standard looks to the individual and the information they are seeking to keep private. And Chester Comerford was seeking to keep his movements private. Therefore, when he was traveling in public and when law enforcement were able to use routine technology to obtain this information, he has no privacy interest in that information
But what you're really doing is you're restating what the law is. You're basically making a conclusion. The conclusion is he had no reasonable expectation of privacy. Let's go back from that point and distinguish for me the Supreme Court case that has held that the pen register is one, or law enforcement obtaining a pen register is one that's not protected. And then under the case by the Supreme Court that said it is protected, where there is thermal imaging devices that will indicate or constitute a search, because that technology is not available to the public, and it's considered an invasion of privacy, but not only invasion of privacy, but no reasonable expectation of privacy. So where are you between there?
Your Honor, respondent would assert that this case is most analogous to the Smith case, and that the use of IMSI technology is analogous to the use of the pen registers, as opposed to thermal imaging.
And tell me why.
Because, Your Honors, in the Smith case, this court concluded that the use of pen registers by telephone providers was routine. Therefore, law enforcement was able to use that technology without a warrant. In the Kayla case,
with respect to pen registers, the court said that the use of pen registers for law enforcement was something that individuals should expect. But in contrast, in Kayla, the court said this is something that would not be expected by law enforcement or anyone else. So why is this something, this particular capacity, this technology, one that an individual would expect that law enforcement would follow? As I understand it, and correct me if I'm wrong, an individual who purchases a cell phone may well expect that information, the information derived from it as to where they are, is available, but there is an expectation that the company is not going to do that, is not going to follow it. So you're going to have to get to the point where it's reasonable to expect that law enforcement would be following it, like in the pen register case, as opposed to the thermal imaging case.
Your Honor, when applying the CATS analysis, a reasonable expectation of privacy must be manifested against the public. Thus, they have private information. And this court, in the case of California versus Sorello, noted that one cannot expect that the public can obtain it, but not law enforcement. Therefore, we cannot make the distinction that they expect other members of the public to obtain this information, but not law enforcement to obtain this information.
And why?
Because law enforcement can obtain information that is public without a warrant. And if an individual is conveying information to the public, then law enforcement has a right to also convey that, to obtain or observe that information.
The government announced that it was going to cap everybody's phone conversation, both land phones and cell phones. Is that constitutional for them then to do it?
No, Your Honor, because...
Why not? They've announced they're doing it, so you don't have an expectation of privacy.
Your Honor, they may have announced it. However, this court has enacted certain judicial safeguards against the obtaining of content. And if law enforcement were wiretapping phones, they would obtain content of conversations, which this court struck down in the case of Kayla.
What's the constitutional difference between content and information like they got in this case of people's movements?
Because, Your Honor, content by its nature is private. However, public movements is public.
That's what you say, but why should we say that? What's the difference? Why is the word I speak private, but where I go is not? Why is that?
Your Honor, because this court has derived that role based on personal associations, and the conversation one has between individuals is intimate. Thus, content has been preserved by this court's jurisprudence.
It's not intimate if the government's tapping your phone.
Your Honor, if the government is tapping your phone without a warrant, that would be unconstitutional.
Why? If they announce they're going to do it, I don't have a reasonable expectation of privacy.
Your Honor, one would have a reasonable expectation of privacy, and it is instructive to note that in footnote 5 of the case of United States v. Knox, Justice Rehnquist noted that the reasonable expectation of privacy standard may not be applicable in such cases if the government were to explicitly state that we are living in a police state. However, based on the jurisprudence in our court and based on the evidence in the record, when Chester Comerford was conducting his movements in public and law enforcement was using routine technology not to obtain content, but to obtain public information, they were acting within their rights because Chester Comerford lacked a reasonable expectation of privacy. Therefore, we ask that you affirm the decision of the lower court.
So now, we have the Congress made clear before you can discover, learn private conversations, there is the wiretap law. So whether it's constitutional or not, you have the wiretap law that has very complex and exquisite requirements where you have to go to the court, it's all confidential. And so we have those conversations that are considered protected. But they're protected because, in fact, Congress has said they're protected. So, but beyond that, we don't have a congressional determination, so we're back to constitutional protections. Why then are these protected or not protected?
Your Honor, I see my time is about to expire. May I briefly accede to answer your question?
Yes.
Your Honor, while I cannot speak in detail regarding the wiretap law, which would take us outside the record, based on this court's jurisprudence we have in our closed record, this court has afforded protections against content. And law enforcement in this case did not reveal any content regarding Chester Comerford's phone. They only obtained information he was conveying to the public when he traveled in public. They only relied upon information regarding his public movements. And that is what was dispositive in this case. And therefore, law enforcement asserts they were acting within their rights to obtain this public information. And we ask that you affirm.
And do you think the subjective belief prong is still viable? If we know anything, we know that technology keeps going. We're not going to have in 50 years a reasonable expectation that anything is private. Subjective belief goes out the window. Isn't the end game that everything is discoverable?
Not necessarily, Your Honor. And the subjective expectation prong is important, and the government concedes Chester Comerford may have that. But based on the information he was conveying and based on routine technology, he does not have a legitimate expectation of privacy. And respondent does acknowledge that in the cases of advancing technology, it may diminish certain rights. However, this court notes in the case of Smith v. Maryland that sometimes when using advanced technology, one must assume the risk of disclosure. Thus, if one makes the choice to use advanced technology, they may in some way sacrifice an aspect of their privacy rights.
Isn't the advanced technology, the device that's tracking him, the phone itself, if someone doesn't know that the phone is capable of doing that, or that it's being done, why isn't it reasonable to think that you can still keep your whereabouts private, if you're not actually activating the GPS on your phone?
Your Honor, I see my time has expired. Can I answer this question?
Okay.
Your Honor, this would bring the court's attention to the inherently traceable nature of this type of technology. And although the general public may not understand the intricacies of this technology, they do understand the main function of a cell phone, is that it must convey its location if it is to have mobile function. Therefore, if an individual wants to preclude this type of surveillance, they should simply turn their phone off when traveling. That would preclude law enforcement as well as the public from ascertaining the location of that device using IMSI technology. Because inherent in cell phone technology is the requirement that it broadcasts its signal in order to have mobile communication. And based on this public information that was obtained constitutionally, we ask that this court affirm the decision of the lower court. Thank you.
Thank you. You may proceed.
Madam Chief Justice, may it please the court. My name is Kyle Maury, and I continue arguments this evening on behalf of the people of the United States. We ask this court to affirm the ruling of the 14th Circuit because the President's actions were constitutional. Your Honors, this case is about the duty of the President to protect the American people and the nation from acts of terrorism. And in this case, the President acted constitutionally for two reasons. First, Mr. Comerford committed a belligerent act in violation of the laws of war and is subject...
How do we know that?
Your Honor, based on...
It's never been tested, except by the grand jury that wouldn't indict him, right?
Yes, Your Honor. Page 5 of the record indicates that Mr. Comerford met with military-grade weapons dealers who have suspected ties to Al-Qaeda in his attempt to acquire a dirty bomb. Now, page 7 of the record indicates that both parties have stipulated the facts, and Mr. Comerford recognizes that he was arranging to acquire a weapon of mass destruction. This is a violation of the laws of war. Citizens having control of a weapon of mass destruction is unprecedented. These types of weapons are tightly regulated by the international community.
The laws of war prevent me from making an atomic bomb?
Your Honor, the laws of war would subject you to military detainment for your act in trying to make an atomic bomb.
Would that violate the laws of war?
It would
I'm
violate...
not at war with anybody. I'm just making a bomb or weapon of mass destruction.
Your Honor, the only motive behind making that type of weapon or acquiring that type of weapon is to use it. And such weapon can inflict massive casualties on civilians and non-civilians alike. And as such, an individual person having control of such a weapon, when certain countries in the world cannot control these weapons.
If there were no link to Al-Qaeda or some known terrorist group, your position would still be the same. You're saying it doesn't matter, no one can make or transport a bomb?
No, Your Honor. Under that theory of the case, it would be completely different. There must be an international aspect in order for the President to use the authorities bestowed upon him in the Authorization for the Use of Military Force and the National Defense Authorization Act. The President in this case is acting under the first zone of Justice Jackson's Zones of Presidential Power analysis in the Youngstown Sheet and Tube v. Sawyer case. Zone 1 states that when the President acts pursuant to an express or implied will of Congress, his power is at its maximum. And that such an act is supported by the strongest of presumptions and the widest latitude of judicial interpretation, and that the burden would rest heavily upon anyone who might attack it. Now, the President in this case is acting pursuant to the express and implied will of Congress. Congress passed the authorization of the use of military force.
Did the President ever have a hearing? Did anybody ever have a hearing about whether this person, the defendant, had this weapon and what he was using it for? Or what wanted to use it for?
Yes, Your Honor. Page 6 of the record indicates that Mr. Comerford was permitted an administrative review tribunal which reviewed his status as an unprivileged enemy belligerent.
What did that tribunal find?
That tribunal affirmed the President's decision based on the fact that Mr. Comerford has not been released from military custody.
What did they find about whether he had the weapon and what he intended to do with it?
Your Honor, the record is silent as to whether or not the Administrative Review Tribunal made any findings, but rather the record is...
How can you hold somebody without making hold somebody on the assumption that he's doing something wrong without ever making any finding that he's doing something wrong?
Well, Your Honor, the Administrative Review Tribunal granted Mr. Comerford access to counsel, access to evidence against him, access to relevant...
What did they decide?
Your Honor, while the record is explicitly silent on the fact that they affirmed the President's designation as an unprivileged enemy belligerent, it is inferred, based on the language, that the Administrative Review Tribunal reviewed his status as an unprivileged enemy belligerent, and the fact that Mr. Comerford remains in custody under the military, that the Review Tribunal affirmed the President's designation of him as an unprivileged enemy
Do
belligerent.
you know what the evidence of that was before that tribunal?
Yes, Your Honor, as indicated on page 5 of the record, which notes that Mr. Comerford met with military-grade weapons dealers who have suspected ties to Al-Qaeda when he was
Well,
trying...
that's the allegation, right? He hasn't admitted that.
No, Your Honor, but he has stipulated to the fact that he was arranging to acquire a dirty bomb. It is an
Mr. Comerford has admitted that?
No, Your Honor. He is stipulated to the fact that the government found evidence that he was intending and arranging to acquire a dirty bomb. Not necessarily that he committed any type of unlawful activity.
In your position as the matter of law, that information derived from the government was reliable. In what form was it contained? Was it in a declaration? Was it contained in an affidavit under oath? How was it presented to establish that it had a reliability such that it could be determined that he wasn't belligerent?
Your Honor, I would turn the Court's attention to this Court's plurality ruling of Hamdi v. Rumsfeld in 2004, in which the Court opined the credible evidence standard. Now, while it was a plurality ruling at Hamdi, it's the only evidentiary standard offered by this Court in a detention-related case. This Court noted that the government must produce credible evidence when classifying enemy combatants, and defined credible evidence as the government having a rational relationship to the conclusion. Now, the Price cases of 1863 and United States v. Curtiss-Wright Export from 1936 recognize that this is the power of the President to determine who is a belligerent.
But there has to be, the President doesn't have untrammeled power. There has to be some basis upon which the President can make that determination, and that has to be established by law. It can't be established by the subjective determination of each President of the United States. Is that right?
I would disagree, Your Honor, in the regard that this Court recognized that any President in future generations, from when it made those rulings, would be able to interpret each individual set of facts and determine what is a threat against the United States and who is a belligerent.
I agree with that each President has to make that determination. But each President cannot, do you agree that each President cannot rely on his or her subjective determination, that there has to be some criteria that establish it? Are we looking at, for example, the dictionary as to what the words mean? Are we looking at, say, for example, Black's Law Dictionary as to what it constitutes? Do we look at history? Do we look at case law? So, in that sense, distinguish it. And if I'm President of the United States and I'm making that determination, how do I do that? I'm a judge, but as a president with all those powers, how am I going to make that decision objectively and in the interest of the United States?
Your Honor, the President in that situation could look both to case law as well as the changing events in the type of warfare in which the United States finds. Now, in Ex parte hearing in 1942, this Court ruled that it was constitutional that an American citizen be detained and tried by a military tribunal because they were acting on behalf of a foreign enemy of the United States.
In a foreign country?
From a foreign country, Your Honor. Well, he was an American citizen, Mr. Hopt in that case. He was born in the United States, went to Nazi Germany, and came back to attack the United States. Now, while that case establishes that there is a direct connection between the German military and his actions, the unconventional nature of modern warfare creates a presumption that the executive branch has wider latitude to define enemy combatants and therefore to protect the nation from such acts of terrorism.
Why is the executive branch holding this defendant?
Your Honor, because the President in his determination availing himself of his authority under both case law as well as...
What's the charge against him?
Your Honor, Mr. Comerford has not been charged.
But what are they holding him for? Why are they holding him?
Well, Your Honor, page 3 of the record indicates that unprivileged enemy belligerents are not required to...
This person, why is the president... If I go to the president and say, hey, why are you keeping that person? What would he say?
The President would say, Mr. Justice, Associate Justice, that Mr. Comerford is a threat to the United States because of his actions in trying to acquire a weapon of mass destruction.
And where's the check and balance in that? What stops him from saying, sending Judge Brain to Guantanamo? I think he's a threat to national security and trumping something up. The courts usually stand up and allow that to be tested. Who saves you and others?
Your Honor, in that particular instance, the Combatant Status Review Tribunal, as noted on page 6, would review the determination
That's
of the
someone that
President.
answers to the President, right? It's part of the executive?
It is part of the executive branch, but this court just 6 years ago in Boumediene versus Bush recognized that it had no doubt that military courts would obey the Constitution. And as such, this court has already affirmed that it trusts military courts to make such determinations.
Is there any concern about the history between the president and this defendant, or this defendant's previous conduct seem to demonstrate an animosity? Doesn't the president, in a sense, have a conflict of interest with regard to this guy?
Madam Chief Justice, I see my time is about to expire. May I briefly exceed the answer?
May.
Your Honor, that plays no fact in this particular case. The fact that Mr. Comerford was previously charged with aiding and abetting threats against the President plays no role. What does play a role is the fact that Mr. Comerford arranged to acquire a dirty bomb, a weapon of mass destruction which poses a significant security risk not only to the nation but to the American people.
And we have to take that as undisputed. And the cases that we have, previous cases, the precedent that we have, it seems to me that it's also undisputed. Say, for example, in the Price case and other cases, that it was clear. And you also mentioned that in the Quirin case, that was clear. But what we don't know here is the reliability of the information that was presented to the President by law enforcement. We don't know what form, we don't know if it was whispered in his ear, we don't have any of that information. Understanding the President is in a position where he or she has to accept and move on in an expedited basis, accept some information is accurate. But what was it? What was the reliability of that information?
Your Honor, the record is silent as to the reliability of the evidence.
Okay.
Thank you.
Madam Chief Justice, and may it please the Court, petitioner respectfully submits 2 points of rebuttal. First, mere allegation is insufficient to punish an American citizen. And second, dragnet surveillance of American civilians is always unconstitutional. Now, as we examine the first point of rebuttal, it is important to note that within the record, all that exists are allegations against Mr. Comerford, allegations which have never been proven in a court of law. And it would be foreign to this court's jurisprudence to hold that an American citizen...
Does it have to be proven in a court of law? Does it have to be proven to a military tribunal?
Respectfully, no, Justice Fender. They would have to be proven in a military court, as was applied in the case of ex parte curing. In the case of ex parte curing, the individuals were suspected of violating some laws of the United States and some laws of war, and they were subjected to a military trial. They were not merely given review status tribunals. Review status tribunals are only applicable to lawful combatants, and that is not what we have in the case of Barr. So the fact that there are review status tribunals is utterly irrelevant to this case. What is relevant is the fact that Mr. Comerford, an American citizen captured on American soil, is being detained potentially for the rest of his life without ever having his day in court to prove his innocence. All that he is asking is that he have the ability to go before a court of law, be that military or civilian, which would have the ability of pronouncing him innocent or guilty. He has been denied this right, and that is what he is contesting before this court today. When American citizens captured on American soil can be detained for significant portions of their lives on mere allegation, the very safeguards of our constitutional liberties are being eroded.
Would this case be different if you were a Canadian citizen?
Probably not, Your Honor. If he was still being considered an unlawful combatant, all unlawful combatants detained by the president must be tried. The fact that he is an American citizen would indeed bolster his claim because he has direct constitutional liberties that the president is bound to protect.
And other people don't?
Your Honor, it would depend upon the jurisdiction of that case. Presumably, a Canadian citizen, if being held as a violator of the laws of war or a war criminal, would still be receiving a trial. In the case of ex parte Kieran, the German citizens in that case were still given a trial. What is important to note, though, is that violators of the laws of war, when they're suspected of being violators of the laws of war, must be found guilty before they can be punished. That is the link that is lacking in the case of Barr, and citizenship really doesn't matter for the purposes of that analysis. Turning this court's attention to the question of dragnet surveillance. This court, in the case of United States versus Knopf and United States versus Jones, made it clear that any time the government takes a step which can be constituted as dragnet-type surveillance, that is unconstitutional and a violation of the expectation of privacy. And dragnet can be met by the standard of going deep into an individual's life and vacuuming up all areas of their expectations of privacy, or by monitoring a large number of people. In the case of Barr, we have a precedent that will be set if the government's case is affirmed, which would leave the government perfectly free to monitor every single American citizen at any whim that they so desire.
Why do you say that? Why do you say that?
I see my time has expired. May I briefly answer the question? Opposing counsel has raised the argument that there is no expectation of privacy over an individual's cell phone. If there is no expectation of privacy, there is no limitations on what the government can do with that information, meaning that it would be perfectly feasible under opposing counsel's
No
statement.
expectation of privacy based upon the information in this case. Not in every case.
Your Honor, what opposing counsel is saying is that chum-like devices do not violate the expectation of privacy. And if they do not violate the expectation of privacy, they can be used in any and every case without any restrictions upon them. That is the danger posed by this case, and why we would urge this court to reverse the lower court's decision.
Thank you. Good evening, everyone. I am Judge Rosalind Silver, and I'm happily a graduate of this wonderful law school. Second class, 1971. So I'm not sure how long that is. What is it, 42? 5 years. That's okay. Thank you. And I've been a federal district court judge for 20 years. Prior to that, I was with the United States Attorney's Office and Department of Justice for 14 years. And then prior to that, I actually worked for the Navajo tribe. I was counsel for the Navajo tribe. And I was in private practice, and I clerked for the Supreme Court of Arizona. I'm very honored to be here, and you all did an excellent job. I'd like you to appear in my courtroom as soon as you get along.
I'm Mark Brain. I'm a judge of the Superior Court here in Maricopa County. I've currently got a civil assignment. I've been with the court for 7.5 years, both as a commissioner starting out on the juvenile bench, and for the last 3 years on the civil bench. I also handle the general stream adjudication, dividing up the surface waters throughout Arizona. Outstanding job. I wish I saw that quality of advocacy in my courtroom every day. Some people do a pretty good job, but you've done better than a lot. So I applaud all of you. Very nice.
I'm Kent Catania. I'm on the Arizona Court of Appeals. Prior to that, I was at the Arizona Attorney General's office for 22 years. I thought you all did an excellent job. Certainly your arguments are equal caliber to the ones that we see in the Arizona Court of Appeals on a regular basis.
I'm Paul Bender. I am a member of the faculty of the school that Judge Silver was with. Thanks for saying nice things about.
I would say nice.
I teach constitutional law, and I was a law clerk to 2 appellate judges, a Supreme Court justice, and a Court of Appeals judge in the Second Circuit. And I also argued frequently before the United States Supreme Court when I was in the Solicitor General's office of the United States. I was just bowled over by how well. This is a very complicated case, and I thought you people always mastered the substance of it really, really well, and I congratulate you.
I am Shelley Silva, and I'm Associate Dean here at the College of Law. I have worked with students at law schools for almost 20 years of the wonderful career that I've had. And I've seen thousands of students come into law school and graduate law school and go on to wonderful careers. And I have to commend all of the competitors in this tournament. I had the opportunity to judge rounds last night as well, and the quality top to bottom of the competitors in this tournament was just phenomenal. You coaches are to be commended for all of your work. This final round was fantastic. You all have truly gotten what it means to pull all of this information together and be able to discuss it and engage with the material on a much deeper level, and I really enjoyed this round. Thank you.
Thank you.